All right. Now, the gentleman at the jail, remind me who you... Oh, you're Mr. Patterson's client. Does Mr. Patterson want to take him up?
I am not Mr. Patterson's client. I am representing myself because I fired him the day I saw him.
And Judge, there's an email to you this morning.
It doesn't matter. Patterson is not representing me.
Okay, do not talk like that to him in this courtroom, sir. All right. I'll check your email. I'll check my email. Will be just a moment. We are back on the record in BU 2026 CR 169, State of Kansas versus Heath Aaron Brundage. That's you, sir? If you'll unmute, please.
Trespass on the wrong address.
You're not Aaron Brundage?
I'm Heath Aaron Brundage, and I'm representing myself because Patterson is not my lawyer. I done told Ricky.
All right, sir, you're not in charge of this hearing. You're not in charge.
I may not be. I may
you
not be.
better stop it, or I'm going to have him find you. I'm going to find you in contempt and have you serve a sentence for contempt and pay a fine. So just settle down.
He's not representing me.
No, I'm not representing you.
No,
and you know what? I'm not going to let him represent you. Mr. Patterson does a great service to this court by taking our appointments when folks can't afford their own counsel, and I don't want to disparage him for his efforts and his willingness to take his valuable time to take appointments. Now, you told me you couldn't afford an attorney, and we went over your financial situation, and you couldn't, and Mr. Patterson graciously agreed to help you, and now he has filed a motion to allow him to withdraw, and that is granted, Mr. Patterson. Thank you for your service in this case.
Thank you, Judge.
Now, what's so funny, sir? Mr. Brundage, what's so comical?
Nothing's funny, ma'am. Here's the problem. We got this paperwork, and it's notarized by Amber Norris. It's Heath Aaron versus State of Kansas. And on it, it says 6963, which is the wrong address because my car's at my parents' house, and that's what they were criminally trespassing me for, but technically that's called abatement. Abatement is when you have permission to have your property on somebody else's property. I have the keys. It's locked. I'm the owner. They were trying to criminally trespass it, and they got the witnesses on the back as my mom and dad. That's case dismissed because 6963 is the neighbors to my parents.
So I think you're saying you want to be your own attorney.
Yes.
And it sounds like you're trying the case, but as your own attorney, you need to know this is not your trial. This is your pre-trial conference.
Okay, then
Would you like to know the difference?
I would like to put a motion in to dismiss or OR because it would save you $100,000 instead of $390 for wrongful imprisonment. It would be $390 now, but it'd be $490 if you continue the trial. And he said a $750 bond, which I can't afford because right now I'm jobless. And Ricky did it on purpose when he knew that this was a BS charge.
You need to learn respect, sir, for the court system. You don't have to respect us, but you need to learn to show the respect, or at least not disrespect.
I'm ADHD.
Who's Ricky? Is that Chief Judge Ricky?
David Ricky. He's the one that did the setup and all this. And that was my pre-trial. I told him trial by jury.
You are set for trial by jury, but this is your pre-trial to that jury trial. Your jury trial is set for later this week, and I am trying to decide if it's going to be the prime or if one of these others is.
Well, all I'm asking is, ma'am, Your Honor, is that you OR me because it's when I go to court, I'm going to win. I'm not being disrespectful. I'm just saying I will win.
Well, I'll bet the county attorney thinks they're going to win when they go to trial too, and you can't both win. But anyway, depends on what your version of win is, I guess.
They don't have the evidence to prove me to be convicted.
Well, that's for a jury to decide.
And I'm going to love that.
Now, sir, you were charged May 18th of this year, 2026. You were charged with the allegation of on May 16th of 26. Unlawfully, stop it.
Police brutality.
Do not interrupt me. Unlawfully entering or remaining upon land at 6963 Southwest 62nd Terrace, Augusta, Kansas.
Okay.
You knew you were not authorized or privileged to do so, and such premises or property was posted in a manner reasonably likely to come to the intention of intruders, or were locked or fenced or otherwise enclosed or shut or secured against passage and entry. That charge is criminal trespass, a B, non-person misdemeanor.
That's
It
my
count-
parents' house, ma'am.
You can trespass on your parents' property the same as you can someone else's. Count May 17th, 2026 says you went into that same property without permission or while it was locked and you knew you weren't to be in there. Criminal trespass again, but that was the next day, May 17th. So you're looking at 2B misdemeanors, both criminal trespass.
Can I ask a question?
Just because they were your parents doesn't mean that they couldn't
It's
tell you.
abatement. My property's on my parents' property. It's my car. My car is on my parents' property. That is abatement in the law library in the tablet.
Well, you can convince the jury of that if you.
I got it. I got it.
All right.
It's gonna be what? Okay, so you're saying what? This next week I get it? It was what, 5 days? So that'll be 25,000 more than 390.
Sir, you're not making any sense to this court at all.
I'm talking it's $5,000 a day for wrongful jailing. I'm gonna get it.
Well, your confidence is curiously placed. But at this time, I am going to have the officers take you back to custody, and I will let you know if you're going to be the prime trial this week or if I'm going to have to set it over for another month or two.
Send it over for another month or two so I can make more money.
Mr. Baca. Wait, Deputy, before you take him. Mr. Baca?
Your Honor, at this time, the state does want to make a motion to determine competency under 223302. I think, especially since he is going to be representing himself, between the comments he's made here today, as well as some incidents at the jail, which I can go into, I think there may be a competency issue, and I believe it might be proper to get an evaluation to see if he is competent to stand trial. Also might help if he's going to represent himself as well.
I'll pass it 110%.
Mr. Baca, your position is well taken, and I will order a competency evaluation, and we will need to set this back.
More money.
We'll need to set this back once we get the evaluation.
So does that not make it the 23rd like it originally was?
We're going to get you a competency evaluation. You're ordered to comply with that evaluation. I want it done as soon as possible in the county jail. And Mr. Baca, can you do the necessary paperwork to get the evaluator out there to the county jail?
Yes, we can make sure that gets done, Your Honor.
Okay, and I would okay.
And ma'am, there's a police brutality in Augusta at Walmart, and here while I was at the jail, I got nailed with pepper spray balls, and that's Repstein's pepper spray gun, and then they nailed me with the illegal shield that's got problems. It's like 200 to 600 volts. I was sleeping and they nailed me with it. And Lawrence got hurt. He's a sheriff's officer. He was injured during the incident, and Mike approved this. That's the small man captain. So I just want to get that out there. And Hall, when he arrested me on the dirt road, which wasn't on the property, he also did police brutality because the cuffs were way too tight and he did it on purpose. Thank you, ma'am.
Thank you, sir. Now we will go ahead and do that evaluation. You said you'll pass it 100%. That's great, but I just need to see that, especially as Mr. Baca said, if you're going to be representing yourself, I just need to know that you're healthy and able to do that.
No problem. More money.
And Your Honor, was the court going to set a review hearing date?
I would like to, especially since he's in custody and I don't want to lose the case. Do you have any suggestion as when to review that?
Your Honor, not a specific date. I do believe under 3302, however, we are to have the evaluation done within 60 days. I would say at least 30, hopefully before 60.
I'm loving this shit. That's a hell of a paycheck. That's going to be $750,000.
Let's see. This is August. If we put, I don't want to really do this competency on the next review date. Jenna, do you have something you could, a special setting you can maybe put that on one of my Wednesday 1:30s?
I have a Wednesday, November 9th I apologize.
How are
That
you
might be-
doing, Jennifer?
I apologize, Your Honor. Give me one moment.
Yeah, that might be a little too far out. 30 to 60 days. That's what you suggested, Mr. Baca?
Yes, at least 30 to give plenty of time, and then before 60 to comply with statute, I believe, Your Honor.
Right, thank you.
I'm fine with that. That's more of a paycheck for legal standings.
Are you representing yourself in your civil action too?
But civil action. Yeah, I'm representing myself in the police brutality. There's 4 of them.
Action.
There's Hall, there's Weber and Augusta, and there's Lawrence, and there's Durham. And there's a camera here that has evidence on the 2 police brutalities with Lawrence and Durham.
We do have a Wednesday afternoon, September 23rd, 1:30.
That's a whole nother fucking 2. That's almost 2 months.
What's your language? That's yet another issue you've got there. All right. So we're going to continue this at the, I don't know. We're going to continue this for competency motion hearing to Wednesday, September 23rd at 1:30 p.m.
Does that push the court date of the actual trial further? Because I'm loving it if it does.
You're what?
So you're doing a competency thing that's in 60 days or whatever, and you're going to September 23rd. So does that?
Well, good
I'm
for
going
you.
to push your trial even further. Yes.
Cool. That's more money.
All right. Thank you, sir. Now, at this time, you are self-representing, but we may revisit that again.
I don't want a lawyer. I'm not paying for one.
I hear you. We'll make a docket note that you are insistent you don't want a lawyer, that you want to represent yourself.
That's how I make money. They can't railroad me.
Okay, and we might just make a note that he's also representing himself on, you said 3 police brutality actions?
Yes.
Okay, all right.
4. It was 4, ma'am.
4 now, 4 now. Okay, thank you for straightening me out. Okay, sir, you may go. I'm going to remand you to the custody of the sheriff, so you can go back to your cell now.
Do me a favor. 20. What?
And Mr. Baca, your office will let the South Central or whoever know that they can go in and evaluate you. When that
Yes, Your
paper's
Honor.
over. Thank
Edit.
Are
You
you
just stay where
okay?
you're at, though.
Oh, I was like, are you okay if she sits? Because
Yes.
she struggles a little bit.
Yes, you can have a seat, Miss Pettit. Just stay right there in the center somewhere.
You can sit on one of these chairs. Yeah, there you go. Just like that.
All right. So, Miss Pettit, I am Judge McNamara. I'm going to talk to you about these municipal court matters that you have in front of the court today. They are Class C misdemeanor, fine only type charges. Because this is a municipal court hearing at this point in time, I need to go over with you some rights that you have under Article 1517 one more time. If you'll listen to those again. 1, you have the right to remain silent. Any statement that you make can and may be used against you in court. 2, you have the right to have an attorney represent you on your charges. And if you cannot afford to hire an attorney, then the courts will appoint you one. 3rd, if you're questioned or interviewed by law enforcement officers on your charges, you have the right to have an attorney present with you during the questioning or interviewing, and you can stop the questioning or interviewing at any time, whether or not you have an attorney present with you. 4th, if you're charged with a felony offense, you do have the right to an examining trial that would take place prior to your indictment or your official charging in that matter. And then finally, if you're not a citizen of the United States, certain criminal convictions can result in your deportation or in your denial of naturalization or citizenship to this country. And those are your rights that you have under Article 1517. Do you understand those rights that you have?
Your Honor, I do believe that there must be a contract, if I would be able to see this contract, that has obviously been a breach of contract that I'm not aware of.
Right.
These things have gone to a misdemeanor. There's not an injured party that I know of.
Yeah.
But
if you'll let me finish talking to you, we'll get through some resolutions for you, Miss Pettit, if you'll hold on a moment, okay? I need to finish what I'm going over with you first, okay? And then you'll have an opportunity to respond if you need to or ask any questions at that time. So one of the new these are all Class C misdemeanor, fine only charges that I'm going to speak to you about. On these types of cases, we do not appoint attorneys to represent you, but you can always hire someone if you wish to. And on these cases, you're not going to need to make a bond to be released from jail. You're just going to need to follow up over at municipal court to take care of any remaining business that you have over there later. You'll need to go over there in the next 2 weeks between now and Monday, August 17th to take care of your business there. You do get any of the jail credit that you have towards any fines and court costs that you're owing. And I'm going to tell you and talk to you about your jail credit when I speak to you in a minute. Now, the first thing you have is a new charge. It's a Class C misdemeanor offense of possession of drug paraphernalia. That matter will go through municipal court, and I am entering a not guilty plea for you today. So you'll be released on that to go over to municipal court and either set that for trial or plead to it later. If you were to plead to it later, you have a day of jail credit towards the fines and court costs that you're owing. You can also talk to your attorney on your other matters about how to handle that case since they're related out of the same arrest. The other matter that you have out in municipal court is called a capias pro fine warrant. Actually, it's not a capias pro fine warrant. It's a warrant on several tickets that you've received in the past over at municipal court. And I'm just going to kind of generally go over those with you now. I do not have copies of these citations in front of me today, but they do have those over at municipal court. And if you want to look at those, you're welcome to when you go over to municipal court. But we've got violations of expired registration. We have 6, failure to maintain financial responsibility. We have several violations of a promise to appear. There are 6 alleged. There's parking in an alleyway. Hold on, ma'am. There's expired registration, several different tickets for that. There's possession of drug paraphernalia. There's some housing and property maintenance violations.
Yes.
There's a rubbish or trash violation. Let me get through them all and then we'll talk.
Okay.
There's a new driver's license.
Those.
There's running a red light. There's parking where unpaved. There's parking on a sidewalk. And so all of these matters, I need to ask you, how do you plead? You can plead guilty.
I'm not pleading.
Okay.
These are in municipal court under special appearance where they made a ruling behind my back. And
actually, they haven't made a ruling yet, Ms. Pettit. But I am going to enter a not guilty plea for you on these today. And you'll go over to municipal court and you can set those for trial over at municipal court as well. Again, you can also talk to your attorney on the felony case about these municipal court matters, and they'll generally help you out in getting them resolved. But on the municipal court matters, you're not going to need to make a bond to be released from jail. You just need to follow up over there to take care of your business. If not, then warrants will issue again. You do need to make bond on the felony case to be released from jail. And then you'll talk to your attorney about those charges. When you do leave the courtroom today, you're going to get to make a phone call. It's right around 3:30 on a Monday. And that's everything I needed to go over with you. So, did you understand everything?
I don't understand it. The Judge Hernandez had gotten documentation for these previous.
So anything that you've dealt with Judge Hernandez, you're going to have to go back over there and talk to him again.
Were you aware that there was under special appearance for jurisdiction that
Ms. Pettit, all I have is these warrants in front of me today. I don't have access to their computer system to see what's happened in the past on these. So you'll need to talk to Judge Hernandez. You're going to need to follow up over there, okay?
And see, there was no injured party, and these ago.
I understand these are traffic tickets only, ma'am, and you are not going to have a trial on these today. You have to go over to municipal court to take care of your business on this.
I was objecting that they're being considered a criminal when there is not an injured party, and so I was objecting to that. Again,
well, I'm not making any decision about criminal matters, ma'am. You are going to be released on these to report over to municipal court, and you're going to get copies of the pre-confinement orders that I'm preparing that will release you from jail on the municipal court matters. But you need to make the bond on the felony to be released from jail. And you do get to make a phone call when you leave the courtroom. It's 3:30 on a
Call Mr. Davis's case. This is 26 CR 5954. Mr. Davis, sir, once you get situated there at the table, if you just state your name for me.
There he is.
Hi, Mr. Davis, can you state your name?
Michael Shane Davis.
And Ms. Mascarenas is here on behalf of the people. Mr. Davis.
Your Honor, first, I wanted to let you know that Mr. Davis wanted to go through the agreement, the proposed plea agreement that we've reached with the district attorney with the court prior to signing it. He would just feel more comfortable approaching it that way if the court is doing it that way. If so, I do have a copy of the proposed agreement that we've reached between Mr. Davis and the prosecution.
Ms. Mascarenas, are the victims present?
Yes, they are.
And are they comfortable with the disposition?
Yes, they are, Your Honor.
Okay. And Mr. Baden, you've done a complete Rule 5 and 11 advisement.
I have.
And you believe that Mr. Davis's plea today will be a knowing, intelligent, and voluntary plea?
I do.
And you'll agree that there's a factual basis?
Yes.
And Mr. Davis, sir, I'll need you to speak right into that microphone for me. I'll have a conversation with you about this plea agreement. And if you would, state your name again.
Michael Shane Davis.
Mr. Davis, how old are you?
And just before the court gets into it, I wanted to let the court know that we were hoping to approach it as an offered plea, just to let the court know Mr. Davis does not have a lot of memory of the events in question, so that there's the reason for that.
Okay. And then, Mr. Davis, would you state your name again?
Michael Shane Davis.
Mr. Davis, how old are you?
35, sir.
And how far have you gone in school?
I've graduated high school. I went through some college. I haven't verified on paper, but I think I have all the doctorates. So about 12 of them.
When you say doctorates, are you like postgraduate degrees?
Yeah, that's
like,
yes, yes, Your Honor.
Give me an example of one of your postgraduate degrees.
Well, there's 12 doctorates you can't have, so chiropractic would be one of them.
What are the other ones that you have, Mr. Davis?
Also, make neurosurgery, neuroscience, cardiovascular, intestinal, reproductive.
Okay. So you're a surgeon? Is
Uh,
that your job? Is that what you do for a living?
I don't know how it all works, Your Honor.
Where did you go to school, sir?
I know I took some online at the Independence University, the university here online at some point. Yeah, I just wanted to bring those up because you asked about schooling. So,
With all due respect to you, Mr. Davis, I find it kind of hard to believe that you have 12 graduate degrees. Are you sure that you do?
I'm pretty sure, Your Honor.
Okay. So, Mr. Baden, I'll be honest with you, I'm not comfortable taking this plea with that understanding unless you can provide to me documentation that would show that what Mr. Davis is talking about is accurate. Otherwise, I'm kind of concerned about his competence to proceed.
Understood, Your Honor. I don't have any documentation to support that he does have the doctorates. I also did have some competency concerns, as I raised with the court earlier, and was hoping that we could get him out of court so that we could examine those. Despite those concerns, and I do believe that there are some significant delusions, I do believe that he understands the terms of the plea agreement that we went over. So that's why I was comfortable proceeding today.
Okay. I don't think I'm comfortable accepting the agreement under those circumstances. Do you want me to set it over for a more formal competency advisement, or?
If we could do that, Your Honor.
Okay. So that's what I'm going to do, is I'll set the case for a competency advisement. And I'll put this on. Can we do Wednesday at 1:15? Or in the morning too. I could do the morning. That's better for me.
Actually, not going to be available for this day. Would you be able to do it tomorrow or something?
You know, I don't think I can set it that good. Because of, well, we might be in trial tomorrow, right?
We might be in the trial in the morning. If we're not, then I could do it in the morning. Well, I don't know that we could just do the competency advisement now and then.
Are you comfortable
I am.
waiving any formal competency advisement?
I am.
Okay. Mr. Davis, I'm going to go ahead and order a competency examination for you. Mr. Vaden's waived formal advisement on that, but I'll just talk with you briefly about what that means. I'm going to have you evaluated by folks that are associated with the Colorado Mental Health Institute. They'll communicate with you. I think it may be virtually, it may be in person. I'm not sure exactly how they're doing it now, but they're going to have some discussions with you and make a determination whether or not you're competent to proceed in this case. They'll prepare ultimately a written report and they'll file that with the court. I'll set a review date in about 21 days and ask that they get it done within that period of time. During this process, sir, you do have a right to remain silent. You have a right to speak to your attorney before you speak with the doctors or the folks that are going to do the evaluation. If you would communicate at all about the facts of the case, those communications or statements that you might make would not be admissible if ultimately we had a trial in this case by the prosecution during their case in chief, unless you testified at trial and you testified inconsistently differently than what you told the doctors, then those statements could come in, but otherwise they wouldn't be admissible at trial. The court would be able to consider those statements, though, at sentencing if ultimately you were found competent to proceed and the case proceeded to trial. If you're found not competent to proceed, then we'll have a discussion about whether that restoration should occur on an inpatient basis or an outpatient basis. And then we'd schedule reviews after that. And then ultimately, if you're restored to competency, then we can take the case back up. And if you still want to take an agreement, you can do that, or you still have a right to go to trial also if you wanted to do that. If you're found not competent to proceed, then we'd schedule reviews every 90 days initially. And then at some point, if you're not deemed to be restorable, then there would be some discussions about how the case should be handled at that point. But potentially, the court could dismiss the case. It may be that there's some sort of kind of civil commitment that's initiated. It would also be an option. It would just be dependent on kind of the circumstances and what the evaluations say or recommend. So I'll go ahead and order that competency examination. I'll set a review on August 24th. Actually, I'm going to put it on September. Put it on September. I'm going to put it on off the regular setting docket. I'll put it on September 4th at 8:30. If that works for everybody. The receipt of that report.
Is it 8:30?
8:30, yeah. And then I'll call that a bond hearing also. And I have a suspicion they'll probably recommend outpatient restoration for Mr. Davis. I'll tender this plea agreement back to you, Mr. Davis.
Thank you.
So competency review and a bond hearing September 4th at 8:30. Ms. Mascarenas, anything else today?
I have nothing further.
And then certainly if the alleged victims can be present on that date, I'd appreciate that too.